Under Section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act of 2007, you have a provision that reads, where any senior citizen who, after the commencement of this act, has transferred by way of gift or otherwise his property, subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence, and shall, at the option of the transferor, be declared void by the tribunal. So a bare reading of this provision suggests that the transfer must be made by a senior citizen, because the provision itself reads that where any senior citizen who, after the commencement of this act, has transferred. So is it true that the person making the transfer must be a senior citizen at the time of making the transfer? A senior citizen under this act is somebody who has attained the age of 60. Before answering this question, let us first go and have a look at sections 4 and 5 of this act. Section 4 subsection 1 reads that a senior citizen, including parent, who is unable to maintain himself from his own earning or out of the property owned by him, shall be entitled to make an application under section 5 in case of 1. Parent or grandparent against one or more of his children not being a minor. 2. A childless senior citizen against such of his relative referred to in clause G of section 2. Section 5 deals with an application for maintenance. So when you read these two provisions together, it gives you the impression that any senior citizen can make an application for the sake of maintenance. Now you have two different views with respect to whether a person must be a senior citizen at the time of making the transfer of property in the context of section 23. The first view was expressed by the Bombay High Court and the Punjab and Haryana. According to this view, a person who is a senior citizen at the time of making an application under this act can invoke section 23. So it is the age at the time of making an application that matters according to this view. The first case in that regard is from the Bombay High Court, and the cause title of the case is Nayana Sudhir Shah versus Sudhir Premji Shah. The case number is writ petition number 7982 of 2018. The order was pronounced on 19/5/2020. Now, as per this particular judgment, the court considered sections 4 and 5 of the Act and held that the contention of the petitioners in that case, that the term transfer in section 23 subsection 1 will apply only when the said transfer was or is made by a senior citizen, is not acceptable. So, according to this particular judgment, the age that is to be considered is the age at the time of making an application in order to invoke section 23. Now, subsequently, a judgment from the Punjab and Haryana High Court is Amarjit Singh versus Deputy Commissioner, having case number civil writ petition number 21669 of 2019. The order was pronounced on 22/10/2019. Well, in this case, there was no contention against the view, but it was said that the age was not 60 at the time of making an application, but the court observed that the age was 60 at the time of making an application. So he was a senior citizen and entitled to make an application in order to invoke 23. So here the date that was considered was the date on which the application was being made. Now the second view is from the Kerala High Court in the case of Rajesh versus District Collector. The case number is writ petition civil number 29452 of 2018. The judgment was pronounced on October 22nd of 2018. Here it was said that one of the conditions for the invocation of the provision in section 23 subsection 1 is that the transferor should have been a senior citizen at the time of the execution of the transfer of gift deed or settlement deed, and such transfer by way of a gift or otherwise should have been made by a senior citizen concerned after the act came into force. Further, it was said that if the transferor has not completed the age of 60 years as on the date of the execution of the gift deed or settlement deed, then one of the vital jurisdictional facts will not be fulfilled, and hence the application will not be maintainable. So here the view that was taken by the Kerala High Court is that a person cannot invoke section 23 subsection 1 if at the time of making the transfer the person was not a senior citizen, that is 60 or above. Now, which of these views do you think is right? In my opinion, the Senior Citizen Act being a beneficial legislation, it wouldn't make sense if you excluded certain senior citizens by stating that they had not attained the age of 60 when they made the transfer. Say if a person was at the age of 59 years and 245 days at the time of making the transfer, would it make sense to say that this provision must be strictly interpreted so as to exclude that person from invoking section 23? Or will you make a liberal interpretation of the same and say any person could invoke the provision as long as they are a senior citizen. Now let us just consider this situation. The reason that we state 60 to be the age is that a parent retires at the age of 60 typically. So a person can make the application at the age of 60 saying that I've retired and now I need maintenance support from my children. So at the time of reaching 60 they can make an application. But would it make sense to exclude parents from making an application because they made the transfer at the age of 55 or 56? Because they made the transfer back then, but now they are senior citizens, they have retired, now they need maintenance. So it would be appropriate to say that the correct time to be considered would be the age at the time of making the application. Also, it must be considered here that section 23 subsection 1 does not specifically state that the person must have been a senior citizen at the time of making the transfer. It also doesn't say that the person must be a senior citizen only at the time of making the application. So it could go either way based on how you want to interpret it. What do you think about this? What would be the right interpretation? Is the Bombay High Court or the Punjab and Haryana High Court right? Or is the Kerala High Court right? Let me know your thoughts in the comment section. Do subscribe to our channel on YouTube. Do follow us on Spotify. Like, comment, share this with your legal community and check out our other videos on this channel. Thank you.